my name is Emily Hendrickson. I'm going to apologize in advance for my voice. I'm a little under the weather right now, but we'll get through it. So this week's discussion is about the importance of facts, key terms, and ethics in legal research. So first, distinguishing between relevant versus irrelevant facts. According to the book, relevant facts are facts that are critical to the outcome of the case. They are legally significant and raise the legal question of how or whether the law governing the dispute applies. Moreover, relevant facts establish or satisfy the elements of a cause of action, and are necessary to prove or disprove a claim. Irrelevant facts, on the other hand, are facts that are coincidental to the event and are not of legal relevance to the case. Simply put, irrelevant facts offer extra details on a case. Now for the fact application. For precedent or case law, facts serve to help identify similarities between prior cases. This means that court decisions can be influenced by the precedent set by past similar cases. As for statutory law, key facts aim to satisfy the legal requirements or elements for whichever law or statute was broken. Lastly, primary law refers to the law itself and is binding for the court. Secondary sources are sources outside the law, such as law review articles or legal encyclopedias, that are not legally binding but still add valuable perspectives and opinions to a case. While the two authorities work together to help the court identify fact patterns and come to a conclusion in a case, primary sources serve as the base for court decisions, whereas secondary authority simply helps explain the law. And then second, we have key terms and search strategies. Research begins with choosing effective search terms. For example, you can't possibly find information related to property law if you look at a source rooted in family law. Choosing effective search terms is essential for finding beneficial sources. Once a person has a list of key terms related to the issue they are researching, they can then take it one step further by refining their search to a few keywords. This way, a researcher has a significantly less amount of sources to read through rather than perhaps dozens. In this day and age, with the advances in availability of search engines, different strategies for conducting research have grown. Certain strategies that work for one person may not work for another. It is important to understand what strategies work for you and which ones simply do not. Personally, I try to search through indexes and glossaries in the backs of books to find key terms that relate to my research topic. Sometimes glossaries even have see also items that relate to my topic, so I can gather more useful information. And then lastly, we have ethical considerations in legal research. Ethical research is without a doubt one of the most important aspects of legal work. The law is supposed to be impartial, and similarly, legal work should be completed objectively, prioritizing intellectual honesty. Paralegals and other legal professionals all have codes of ethics they must follow that outline competent representation, diligence, and promptness. Errors arising from incorrect citations may lead to a loss of trust and credibility on behalf of the legal professional or the firm in which they work for. Discipline may also be imparted on a legal professional if the action of incorrect citations was deliberate. On the other hand, errors caused by omitting all relevant case law, including negative treatment, can lead to malpractice claims or unfavorable rulings for the client. Double-checking sources, proofreading, keeping up-to-date records, and peer review are all ways to help eliminate ethical mistakes and maintain an integrity-centered practice. And then here's my reference. Thank you.